My name is Justin Myers and I am a Utah bankruptcy attorney. Today we are going to be discussing whether or not a debtor or the person that files a bankruptcy case can dismiss the case after the case has been filed. This and other topics can be read about in a book I wrote entitled Filing Bankruptcy in Utah. You can order a free copy of this book from my website, utahbankruptcybook.com. That's utahbankruptcybook.com. You can also call my office at 801-308-8200, 801-308-8200, and set up a free initial consultation with me to talk about your options. Okay, so at first we will be discussing whether or not you can dismiss a Chapter 13 case. Generally, a debtor may dismiss a Chapter 13 case at any time. This can be done in several ways. The debtor can simply stop making Chapter 13 plan payments, and eventually the Chapter 13 trustee will file a motion to dismiss the case for non-payment. If the debtor wants to quickly dismiss the case, the debtor can file a motion to dismiss the case, and the case will be dismissed. If a Chapter 13 case is dismissed prior to a discharge being granted, the debtor will cease to have protection against creditors upon dismissal. If the debtor wants to refile another Chapter 13 case after the existing case is dismissed, there could be complications if the debtor filed a motion to dismiss the case instead of the Chapter 13 trustee filing the motion to dismiss the case. It is important for the debtor to discuss these details with a bankruptcy attorney prior to filing a motion to dismiss your case. Any secured debts, such as vehicle loans, that were being paid through the bankruptcy plan, the Chapter 13 plan, these loans will revert back to the original terms of the loan. This usually means that the debtor will immediately be delinquent on these debts because secured debts being paid through a Chapter 13 plan are usually paid a monthly payment that is less than the original terms of the loan. If a debtor wants to keep the property, the debtor will usually need to call the creditor directly and work out new terms if the creditor is willing. If the creditor is unwilling to work with the debtor, the creditor may repossess the property. All right, now let's talk about whether you can dismiss a Chapter 7 case. If a debtor decides to dismiss a Chapter 7 case, the debtor will have to file a motion with the court asking for permission to dismiss. The Chapter 7 trustee may object to this motion if the trustee feels like there are non-exempt assets that can be taken for the benefit of creditors. If the judge feels like creditors will be unduly harmed in a dismissal of a Chapter 7 case, the judge may not grant the motion to dismiss.